Good morning, Your Honors. My name is Jim Armstrong. I'm here with my partner, Jeff Leonard, who was the trial counsel in this matter. We represent Maricopa County, County Attorney Montgomery, and the other county defendants and appellees.
So could you, since we're a hot bench, as Judge Wynn says, can you address Miss Aubuchon and Miss Alexander, before they go off on their misadventures, meet with Mr. Thomas? And Mr. Thomas, who's their supervisor, says, I know this is going to be hotly contested. Actually, what he knows at the time is that I'm about to commit misconduct that's going to get me disbarred. So when you go do this, don't worry about bar costs. He's already thinking about bar costs.
You're protected.
You're protected. He's their supervisor. Isn't that some evidence that a contract to pay their bar costs existed?
It would be perhaps some evidence, but if you look in the record, none of that appears. You asked Ms. McCracken several times, what is the evidence of this contract? What is the evidence of this oral modification? The only thing I heard her say were the two affidavits. And I urge Your Honors to read those affidavits. They won't take you very long.
Okay, well, I have them here, so why don't I, let's read the deposition testimony. I know I was assured through management on multiple occasions that any attorney that received any kind of discipline would be covered by the Maricopa County's Attorney's Office for any costs, fees, etc. that were incurred if their work was related to their job as county attorney. Is that evidence that there was a contract?
It leaves off one very big piece of evidence that is necessary for a contract, and that is consideration.
No, she says this from the beginning. This is from day one. My point is that the law in Arizona is that the contract may have been entered into on day one, but the terms can be established by course of conduct and by assurances. So that's one piece of evidence. How about the affidavit? As part of my employment, I was trained and specifically advised that if our disciplinary proceedings were ever initiated, any costs associated with proceedings that alleged ethical violations while I was employed by Maricopa County's Attorney's Office would be paid. So that's the affidavit. What's wrong with that?
What's wrong with that is that does not indicate that this was a promise made on day one of her employment.
No, but
doesn't tell you when.
Maybe it was a promise made later. So their argument is, look, before I set off on my misadventures, I was assured that I wouldn't have to worry about bar costs. And that's consideration. I wouldn't have set off on these misadventures had I not done so. I wouldn't have undertaken this assignment, which I was not required to undertake, had I not been promised that I'd be covered. Why isn't that consideration?
Because that isn't really their argument.
Well, no, I'm not asking what they're arguing. Okay. I may be, as your colleague said to Judge Eaton, I may be doing a better job than she was.
Their position is
so I'm asking the question, why isn't that consideration?
I think their position is what Judge Nguyen said during Ms. McCracken's argument.
Okay, but I'm not asking what their position is.
I pronounce it when.
Oh, sorry.
Okay. I'm not asking what their position is. I'm asking if that's what's in the record, why isn't that consideration?
And when you say that, you mean the quote that
Judge Eaton read to you from the deposition testimony. She said, one of them said, I think this was Miss Aubuchon, I was told many times, and Miss Alexander sort of says the same thing. I was told many times, don't worry, if you ever get in trouble, the county will cover your bar costs. They both say, before I went off on the conduct that got me disciplined, disbarred in one case, suspended in the other, Mr. Thomas reiterated to me that, and I would not have undertaken this assignment but for that assurance. Why isn't that sufficient evidence of the existence of a contract?
Because it was not part of the original terms of the contract. As Judge Logan found, it was a simple...
Let's assume it wasn't.
Okay.
Judge Eaton's point is that it may be evidence. Okay. But let's assume for purposes of your argument that it wasn't part of the initial contract. Why wasn't the contract modified at that point to include that assurance?
Because there was no consideration given for that.
Well, you and I keep going back and forth on that. They say there was consideration because when Mr. Thomas promised me that motivated me to take on this assignment. Had he not promised me that, it's really a strange argument, which is that I was worried about getting disbarred when I took on the assignment. But when I took on the assignment, that was in my mind, and I wouldn't have taken it on but for this promise.
Right. They characterize it. We took on additional duties of a politically insensitive manner.
I wasn't required to go out and file false charges against a judge.
Right.
I wasn't required to file a false RICO claim. But I did it,
right,
in part because Mr. Thomas promised me that I wouldn't have any bar costs if I did. Well, their conduct may have been deserving of sanctions, but the Arizona Supreme Court's taken care of that already.
Okay.
Our question is, why isn't that consideration?
It's not consideration for the reasons Judge Wen said. You cannot, what was promised to be given there, unethical behavior. I will go out and commit unethical misconduct cannot be
That's
consideration.
not what they say. They say, I wouldn't even have undertaken the assignment. And if I never undertook the assignment, I never would have engaged in the unethical behavior.
Their assignments are what they were directed to do by the Maricopa County Attorney. Their assignments changed over years. They were full-time deputy county attorneys. They were given different assignments. There's no indication in the record that this was any kind of a different assignment.
Don't they say I wouldn't have taken on this case. I wouldn't have taken on this assignment in the absence of that promise.
No, they do not say that. And
Tell me what part of the record.
When the issue of consideration was raised, they had an opportunity to put in supplemental affidavits, supplemental evidence to support this argument that we took on additional duties, and those additional duties satisfy the consideration element. They put in no evidence of that. They are stuck with their original affidavits, which make no reference to what Your Honor just described.
How about Ms. Aubuchon's deposition? Any reference in there to that?
No, at least nothing that was put into the record. I mean, she was deposed many times.
Right. I'm just looking at the excerpts of the part that was put in front of the district judge.
Right.
Anything in that record in front of the district judge that says, I relied on that promise?
No, the only place it occurred was in their motion papers as an assertion of counsel. Okay. There was no backing evidence from them, from anyone, from Mr. Thomas. In fact, Mr. Thomas never testified in this case.
So let's go back to Judge Eaton's question, because it's a good one, I think. He says, we don't know what the contract was at the time that they signed up because there's not much evidence of it. But what we do know is that over the course of their employment, when two other ones came up, and I think they were both before Ms. Aubuchon and Ms. Alexander,
I believe
opportunities
so.
to pay costs.
Yes.
The first two opportunities that came up before that involving county attorneys that we can find, the county paid the costs. And then, and add to that, Mr. Thomas, maybe he's got no authority to do so, tells us that don't worry, your costs will be paid. Why isn't that some evidence that gets them to a jury?
I mean, just to add something to this, there's also the mere existence of the trust fund, and that it's available to pay these charges. That indicates something, doesn't it?
Well, the trust fund, I think, is a very simple issue.
Wait,
okay.
Just go back to his question.
Okay. How can that be evidence of a contract? A contract is a negotiation. It's a bilateral discussion. How can something that's happening to a third party, to Mr. Spa, to Mr. Duffy, how can that be evidence of what our arrangement is, our agreement between you and I?
Well, they had the same
arrangement.
Same arrangement with Mr. Spa and Mr. Duffy. So.
Well, they were not in the same situation. It was a discretionary decision by the county attorney and the county risk management to pay Mr. Duffy's costs and to pay Mr. Spa's costs based upon their radically different circumstances.
I'm baffled by this whole notion of discretion. Discretion isn't whim. Discretion is you have an obligation. The discretion is I have an obligation to pay. The obligation has to come from someplace. You can't take the taxpayer's dollar and just give it to somebody because you want to, because they were a good guy. You have to have an obligation to pay that money.
Well, I think Judge Logan's analysis of that issue was correct. The county made a rational, cost-effective decision. Mr. Spa was willing to agree to the sanction.
So it's your position that there's nothing on the record to demonstrate that there was an agreement between the trustees and Mr. Spa that if he would sign the agreement, that they would pay his costs. I couldn't find anything.
You mean a written agreement?
Any kind of an agreement.
No, I don't think there was a written agreement.
So this decision to pay these costs was made after he signed it. So that can't be the reason.
I don't know if I don't know if that is in the record, Your Honor, about the timing of it. And I know that they cooperated, that this decision was made to pay $15,000 rather than having to pay hundreds of thousands in defending this.
Where's that agreement? That's not an agreement. There's no agreement to, I'll do this, I'll sign this agreement to save you any money.
No, you're right.
There's simply no agreement.
That's correct. It was a discretionary decision made by county attorney, county risk management.
Yeah, there is evidence that they made a discretionary decision to pay it for those reasons. But there's no evidence that they'd agreed with either Mr. Duffy or Mr. Spa beforehand that if they did these things, their costs would be paid.
That's correct.
Okay.
But you can't pay government money to anybody unless you're obligated to pay.
Is that, are you aware of any Arizona law that says that, by the way?
I'll cite you the Constitution.
Of Arizona?
Yes.
I'm kind of familiar.
Which is like all other constitutions.
Kind of familiar with it.
You cannot pay public.
Well, I think the county, as any other employer, has the discretion to
It's a
give
cost-benefit
benefits.
analysis, and that way it's an exercise of discretion, is what you're saying?
But it's also, it's within the discretion of the county as an employer to pay health insurance for its employees, to pay defense costs in disciplinary proceedings, to pay sanctions in disciplinary proceedings if they chose to do it.
You paid a lot of money in defense costs, and that's just discretionary? That's not an obligation?
An obligation on behalf of the county to defend.
Yeah, is there an obligation to defend and pay for defense costs?
There was a policy, yes, there was a policy in place in the county policies and procedures that they would defend county attorneys on defense costs. That's different from what we're talking about here in disciplinary proceedings. And in fact, in all of these cases,
Let me ask you the question. I'm sorry, Judge Eaton.
That's not a contractual arrangement?
no, it is not, because if you look under Arizona law, if you look at, I'll call this an employee handbook, because that's where these policies really are. Under Arizona law, if you sufficiently disclaim in this handbook that this is not a contractual commitment, that these policies are changeable at any time, and that's what this handbook said, and in fact it said.
But the handbook doesn't cover costs in any event.
No, the handbook said the opposite. Said that
Right.
in the case you were sanctioned, we will not pay your.
Okay, so I want to ask about Miss Alexander's circumstance, because it seems to me Miss Aubuchon's circumstance is quite distinguishable from the previous cases. She went out and got herself disbarred. Other people got themselves suspended or sanctioned. In Miss Alexander's case, where she gets a 6-month suspension, why isn't it a reasonable inference that the bar has agreed to pay her costs? It's paid them for Mr. Spa, who has what kind of sanction?
He was sanctioned for negligent.
No, what was his what sanction did he receive?
I think it was $15,000. No.
No, bar sanction. He was suspended.
$15,000. That's what the county.
He was suspended from the practice of law, was he not?
I'm not sure that. I don't know if that's in the record.
Wasn't Mr. Duffy also suspended?
I believe so. Yes.
So you have 2 suspensions that occur
Right.
prior to her, and the county pays off on each of them. I understand Miss Aubuchon's situation is quite different. She gets disbarred. But Miss Alexander gets a 6-month suspension. Why doesn't she have a reasonable expectation that her bar costs are going to be paid? Because they've been paid for the people who are in similar
No,
circumstances.
I think
up till
one of
then.
the distinctions the county drew was that both Ms. Aubuchon and Ms. Alexander were found liable for intentional unethical acts. Very clear. If you read the Supreme Court opinion on both. Excuse me?
The other two were not?
They were not.
Well, Mr. Spa wasn't because he
Right.
made a deal.
Right.
Right. I mean, it's the same.
No.
It's the same conduct. It's the same. At least as compared to Miss Alexander, Mr. Spa's conduct strikes me as worse. But he makes a deal. He makes a deal with the bar and they call it negligence.
Well, I don't want to. I could take a half an hour talking about the circumstances of that. It is in the record, however.
It's not in the record that he was only found liable for negligent activity. For instance, respondent participated in and assisted in prosecuting and defending the RICO proceedings and in asserting and controverting issues in it. In doing so, he violated ER 3.1. That is not negligence.
May I grab my copy of the
Here,
record?
you can have mine.
Well, I have a tab.
You're saying because there's no,
If you look-
because he basically resolved the case, there's no specific findings.
Well, I'm looking at SCR 20. There are several paragraphs describing the proceedings against Mr. Spa, and the reference is, I think there is a reference to the finding being that it was simply negligence as opposed to willful misconduct.
See, what, your argument is, well, the other two are very different. And as to Ms. Aubuchon, I agree with you. As to Ms. Alexander, I'm having a hard time figuring out why she isn't comparable to those other two. It may not make any difference.
Well,
but this goes to your argument that your argument was, the other two were very different. And with Ms. Alexander, I have a harder time accepting that.
Well, there's also a difference in that, neither Mr. Spa or Mr. Duffy have made any claim that you are contractually obligated to pay our sanctions in this case.
So respond to Judge Eaton's question. He says, I'm not sure he's right about Arizona law, but I've been wrong about Arizona law a lot of times before. The state could not pay these costs without some contract, or the county, without some contractual obligation to do so. So the fact that they paid them must show that they have an obligation to do so. What's your response to that?
I know of no Arizona law that would preclude that. I think that, again, this is within the discretionary expenditures that the Maricopa County Attorney's Office can make in managing its office and running its operations.
I have one other question, if Judge Wynn, I know we're over
Yes,
time.
we're
here.
taking you over time, but of course.
Mr. Thomas, let's assume Mr. Thomas says what they said he said. Can he alter their contract of employment? Certainly, he can alter their contract of employment in terms of assignment, how much they're paid, other things like that. Why can't he alter their contract of employment in terms of whether or not costs are going to be paid?
I think he probably could, assuming consideration was there.
Okay, so you're not saying and they say he said something. You're not saying if he said that wouldn't alter the contract if consideration was then given?
No, I'm not saying
Okay.
that.
All right. Judge Eaton, any additional questions? No. Thank you very much.
Thank you, Your Honor.
Let's put a couple of minutes on the clock.
Thank you. First, I ask that the court read the trust agreement. The trust agreement says that reasonable costs will be paid and that the board has to approve.
You say that. Tell me where it says reasonable.
2.1.112. And I think I gave you the ER.
Yeah,
I have it over here.
And you think it says that reasonable costs will be paid? I thought it said at the discretion of the county.
No, it says upon approval by the board.
Okay, no, we're saying the same thing. We're saying the same thing. It says.
That is an administrative
Well,
decision,
doesn't it say,
not a.
well, let me just make sure we're talking about the same thing, because maybe I'm missing something. Doesn't the trust agreement say we won't pay for costs of discipline absent approval of the board?
What it says at 2.2.1.12 at ER 259 is the reasonable attorney's fees and reasonable costs arising out of a disciplinary or licensing proceeding before a professional regulatory body upon written approval from the trustees prior to payment.
Right, so what it says is we won't pay those without written approval of the trustee, right?
Yes, but we put forth that it's ministerial, and also remember in this particular case.
Tell me where it says it's ministerial. If it's ministerial, why do they retain the discretion to approve them or not approve them?
Because they're an insurance company and they're the county's self-insurance. But Montgomery said that he made the decision not to pay these costs.
Can I ask you to clarify something in the record on a totally different point? What's the difference between this lawsuit and the state lawsuit that I think is pending appeal right now? Is it for the same thing?
No. The state lawsuit is on all of the things that Judge Hurwitz has talked about, the ethics, the defense fees. One of the fights is that Ms. Aubuchon particularly.
So the request for the prayer for relief in that case was limited to defense fees only?
Yes.
Okay.
And by the way, the Court of Appeals in Arizona did say that there was a contract and remanded to the trial court for terms of that contract.
Have you put that Court of Appeals decision into record?
It is mentioned in the statement of facts.
Yeah, I
in the
know.
trial
I know it's
court.
mentioned in the statement of facts.
And
I'd like to
I-
take judicial notice of it if I can find it. It's a memorandum. It's a memorandum, is it
I
not?
brought copies of it.
It's a memorandum, is it not?
Yes.
Could you
Can
just
I give
file
it
a
to the court, or
just file a
separate?
supplemental 28J citation with that?
All right,
Also-
anything else to add? We've taken you over your time again. Any additional questions?
I have one question. Whether or not Thomas was able to, his statements were a novation of the contract or not, they were certainly evidence of what the contract was. When he represented that these costs would be paid, that was evidence of what the contract was, that they were working under at that moment, isn't it?
I don't think so, because I think we characterize the conversation a little differently. He comes to these two lawyers and says, I want you to do this, I want you to do all this corruption, it's going to be highly political, and I'll protect you, we'll make sure that there are no repercussions. That's a little different than saying, oh, by the way, bar costs. I don't think anybody at the time, although they knew all of this was dangerous, I don't think they were thinking about bar costs. The other thing is, my colleague said that Maricopa County attorney made the discretionary decisions about fees. If that is true, then the county attorney, as an official of the state of Arizona, can both modify the contract and make the discretionary decision. The other thing is that there is no evidence in the record that anybody ever asked the trust board to even look at these particular fees. And before I sit down...
Well, I have a question for you before you
sure.
sit down, too. Judge Wynn is going to...
I'll indulge the
be
panel.
happy with me, but as I'm looking for the Arizona Court of Appeals decision, and I take it that's based on the promise that we will cover your fees, right?
Yes.
It's not, it's not, I don't think the county disagrees today that they promised that their fees would be covered in the handbook.
Well, the
Right.
point is that the Court of Appeals says there is a contract and remanded for the terms of the contract.
But
which is-
the dispute was, as you told Judge Wynn, about
About-
how much fees would be paid.
Right.
And
Not-
everybody agrees there was a contract to pay fees.
I don't think the county agrees that.
Well, I don't know what they did in the state, but
Right.
Mr. Armstrong said there was.
Okay.
Okay.
Policy,
Okay, fair enough.
that they could
All right.
modify at any time.
I know that we haven't argued this at all, but I believe that Judge Logan erred in deciding this one on summary judgment. There are certainly disputed facts.